The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to this session of the Kansas Supreme Court. I welcome both counsel and those who are viewing through our Supreme Court Live channel. You will note that we have 6 justices sitting on this case today. Our newest colleague, Melissa Standridge, who was sworn in earlier this week, it will not be sitting on this case, and we have not appointed a judge to sit in her place. With that explanation, I would now ask Mr. Doug Shima, the clerk of the appellate court, to please call the 9 a.m. docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Thursday, December 17th, 2020 consists of one case. Appeal number 119240, State of Kansas versus Dylan M. Thomas, Wyandotte County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, Peter Meharry, Assistant Appellate Defender for Dylan Thomas.
Madam Chief Justice, and may it please the court, Wyandotte County Assistant District Attorney Daniel Obermeyer on behalf of the State of Kansas appellee, present and ready for oral arguments.
Thank you, counsel. Mr. Meharry, you may begin.
May it please the court. This case comes before this court on a petition for review. Mr. Thomas was convicted of several offenses in the district court after a jury trial, the most severe of which was a charge of rape. He was ultimately sentenced to 620 months, and after his sentence, he appealed to the Kansas Court of Appeals. We raised several issues within the Kansas Court of Appeals. The Court of Appeals found no issues warranted reversal, and we petitioned for review on those same issues with this court. This court granted our petition as to one issue, and that being the second issue that we raised in our original brief. And that was our argument that the district court erred in instructing the jury that, quote, it is not a defense that the defendant did not know or have reason to know that the victim did not consent to the sexual intercourse or was overcome by force or fear. So that is the only issue before this court, and it's our argument that that instruction transformed rape into a strict liability offense and violates the protections afforded by the Due Process Clause. By including that instruction in the whole packet of instructions, we believe that the district court eliminated the requirement to show any criminal intent on the part of my client. And in fact, that instruction allows the district court, or excuse me, the jury to convict even if it believed that my client thought he was having consensual sex. And it goes further, it also would allow the jury to convict even if an objective bystander, a reasonable person, would have the similar belief that my client did. So at the end of the day, all the state had to prove was that my client had sex with the victim. Didn't have to prove anything beyond that as far as it relates to my client's state of mind. So we believe, much like statutory rape, which is obviously rape with a minor, is considered a strict liability offense. You don't have to show any criminal intent on the part of the defendant in that case. You just have to show that the defendant had sex, and that the state has to show that it was with a minor. But you don't have to show that the defendant knew he was having sex with a minor, just that he knew he was having sex. And the instruction in this case, we believe, basically makes rape in the same category. All you have to do, all the state has to do, is prove that my client had sex with the victim. It doesn't require anything beyond that. It doesn't require that criminal intent. Due process talks about having fair notice and fair warning. It requires laws to give that fair warning so that people understand what the law is and can avoid it, that they don't essentially walk into a crime not knowing what they are doing is illegal. There are
Mr. McNary,
exceptions.
I'm sorry. Would you agree that this language comes directly from the statute?
It does come specifically from the statute. It's, outside of switching out the victim's name with victim in the statute, it's word for word from the statutory language, Your Honor.
And don't we usually assume that adoption of a statute is notice to the general public?
But I think the notice here is the actual act, the defendant knowing his act is criminal, not necessarily knowing that this statute is out there and that this statute says that that is not offense. I think due process still requires that the defendant have noticed what he is doing is criminal. Otherwise it is, I think, a strict liability offense, and those are very much restricted. Kansas under 225202 and 5203 talk about every crime requires a culpable mental state, and then goes on to kind of list what are the exceptions. And case law talks about strict liability is the exception, and general criminal liability for other offenses is the norm. So I think here you just don't have that notice to the defendant that what his acts are in fact criminal. So I don't know if that's answering your question or making the distinction, but I think at the heart of our argument is the defendant can act fully believing that what he is doing is legal. And the language goes even further. Not only can he act fully knowing or fully thinking he is acting in a legal manner, but objective third parties would also think that. So it really undercuts, we think, any warning to the defendant that his acts are in fact criminal.
Do we have to strike the statute down to rule in your favor?
I think you do. I don't see a way around that language in the statute that would comport with due process and fair notice.
Wouldn't we have to strike the entire rape statute?
I don't think you necessarily have to strike the entire rape statute. That is, the language for this instruction came from a subsection that is a standalone subsection. So the remaining parts of the statute, I think, can be severed from it. And certainly this, when I looked at when this statutory language came about, from what I could tell, it came about during the recodification. So outside of that, it looked like rape pretty much did not change when Kansas recodified everything. So I think you can keep the rest of the statute and essentially cut out that one subsection. And it is not, the rape statute doesn't fall because that is not in there, as evidenced by the fact that it is a recent addition to the statute. Before recodification, this was not part of the statute, and there was no problems along these lines with the rape statute.
Is our statutory rape statute likewise unconstitutional on the exact same reasoning that you've presented here?
Your Honor, I think there's probably is a difference. Courts have said many times that when you're dealing with children, you have kind of different standards and different protections. So I think there is, maybe a defense, somebody brings up, but I think, probably what courts have said is with strict liability offenses, while they are restricted, while they are, the exception, when you're dealing with the protections of children, states can take stronger protections and say essentially it's on the adult to beware. So I think that is a distinction that part of the statute doesn't necessarily fall with the argument we are making today.
So defendants' constitutional rights are lower when the victims are younger. That sounds like what you're saying.
I wouldn't say that they're necessarily lower. I think the state's interest in protecting children is different than protecting adults. And I think that allows essentially different standards to apply. I think I would argue defendants across the board have the same constitutional rights. But I think what the state can do changes depending on who the victim is. So I think that is a distinction between statutory, what generally is called statutory rape, and rape subsection that we're talking about today. So we believe at the end of the day, this language, and again, I'll emphasize that it's not only my client doesn't know, but also that a reasonable person in his position would not know that his actions are criminal. And due process requires some notice and some warning so that individuals can make choices and avoid and not commit crimes. But when they don't have that notice, they are left at the mercy of the statutes. And we believe that that does violate due process in this case, and a result does warrant reversal for a new trial. If there are no other questions, that's all the presentation I had. And we would ask, as I said, to reverse this matter for a new trial on his rape conviction.
There are other questions? Thank you, Mr. Meharry. Mr. Obermeyer?
Madam Chief Justice, and may it please the court. As the United States Supreme Court recently stated in Collar versus Kansas, the question is whether a rule of criminal responsibility is so old and venerable, so entrenched in the central values of our legal system, as to prevent a state from ever choosing another. And an affirmative answer, although unheard of, is rare. And the court continued that the scope of criminal responsibility is animated by complex and ever-changing ideas that are best left to the states to evaluate and reevaluate over time. I'm going to use my time first briefly addressing the facts of this case, because the defendant is asserting a due process violation. What he's essentially asserting is that his defense was stymied. The facts of this case do not bear that out. I will briefly touch on what I went into more detail in my supplemental brief, that the Kansas rape statute, and specifically the subsection A, what we're talking about, is a general intent crime. And all that subsection E does, which is the challenged portion of this, is re-emphasize the elements in subsection A. And then I'll move on to my third argument, that if this court does find that subsection E, and I would argue by implication subsection A, does render rape to be a strict liability offense, then such a law does not violate the constitutional prohibitions in the due process clause. In this case, the victim, UA, was a mentally disabled woman. Her testimony at trial was that the defendant came to her door, asked for a glass of water, basically tricked her into opening the door, at which point he forced himself in and proceeded to rape her over the course of the day. She described both acts of rape and sodomy. And it's important to note that also she had a hysterectomy about 3 or 4 days prior to this incident happening. She was discovered with the defendant when her son arrived home from school around 3 o'clock that day. The defendant then threatened the son and basically telling him, don't tell anyone about this, and then left. The defendant also testified at trial, and he presented a starkly different version of events. Highly summarized, his testimony was that UA was a prostitute who that morning called him over saying that she needed money, and that he would, and so inviting him over for that exchange of money for sex, basically. He admitted to having sexual relations with her, denied any acts of anal sodomy that she testified to, but admitted to rape. And he testified that he didn't give her the full amount of money that he agreed to. He shorted her $100. And so essentially that's her motive for making up this rape. Now, I bring those facts out because when we're talking about a due process violation, there was nothing in this instruction that prevented the defendant from giving that information to the jury. What did his defense do? Well, it did exactly what happens in the overwhelming majority of rape cases. It was meant to negate an essential element. In this case, the victim gave her consent and that she was not overcome by force or fear. The jury was presented with those options at trial. And this language in subsection E, that is not a defense the defendant did not know or did not have a reason to know that the victim did not consent or was overcome by force or fear. That identical language was used in the criminal sodomy instruction. The jury acquitted the defendant of those charges. And I view that as evidence that this instruction doesn't do what defendant is now claiming it does, i.e. prevents a jury from considering the evidence which is before it and determining whether or not the state has met its claims. Rape is a general intent crime. This court recently acknowledged that in its opinion in State v. Dinkle. The requirement is that a defendant must knowingly engage in sexual intercourse. And that is essentially how rape has always been defined throughout the history, at least as far as the history I could find. There's variations of rape, to be sure, among the many states. That's to be expected. But this historical pedigree, as I note in my response brief, predates the founding of the country in Massachusetts, I believe, to the laws of 1660. So that gets more to the historical pedigree, showing that this provision, this language does not offend the due process clause because of its historical pedigree. But going back to this being a general intent crime, this is clearly has conduct which in the words of I'm paraphrasing the Missouri Supreme Court here, the defendant cannot have knowledge that his actions are criminal in this circumstance because the state has to prove lack of consent and force or fear. This is more an address on the status of the victim. All subsection E does is reinforce the elements in subsection A, because what the victim thought doesn't negate any element in subsection A. He thought that the victim consented, or he thought that she was not overcome by force or fear. That is the practical effect of this statute. As to whether or not the defendant's argument now that it prevents even an objective person from, or how do I say this, that even if the jury believes a reasonable person would believe that that prevents a jury from acquitting the defendant on that, I don't believe is borne out by the statute, because subsection A has to be read in conjunction with subsection E must be read in conjunction with subsection A, because there's no mens rea for the defendant knowing that the victim didn't consent or was overcome by force or fear. So really, it's a reiteration of that. So to go back to Justice Stiegel's question to counsel, I do think that if this court finds that subsection E is unconstitutional, it's probably going to have to find that subsection A is unconstitutional, because then what the state has to prove is that the defendant knew that the victim didn't consent, or wasn't overcome, or knew or didn't know that she was overcome by force or fear.
Counsel, let me give you a hypothetical, and it's maybe a little far-fetched, but I'm just trying to get these terms of the statute clear. If a third party threatens a woman and says, I'm going to make good on my threat unless you seduce a third person who doesn't know anything about this, and the woman does that, is the other person, the person who had sex with the woman, is he guilty of rape because her consent was overcome by force or fear from a third party unbeknownst to him?
I do not believe so, Justice Biles, because the rape statute acts on the defendant. So it has to be the defendant who, in that case, the person threatening, would have to be the person to overcome or to engage in sexual intercourse in order for the act of rape to be completed at that point.
Where is that in the statute?
It's not explicitly in the statute, but it is borne out in the PIC instructions and in the instructions given in this case. I understand that I'm trying to get at the essence of your question here. I just don't think that that's a reasonable construction of the statute to impute the responsibility of a third person to the force or fear applied by the defendant in that case. So I don't think that in that circumstance, the state could convict. And in that circumstance, I don't think the state could charge, and I don't think the jury could convict on that, simply because it needs to be the victim or the defendant knowingly engaging in sexual intercourse with a victim. I mean, what distinguishes the rape statute, moving on to whether or not this is a due process violation, Kansas and Missouri at one point had a virtually identical rape statutes. It's the typical common law definition of rape, carnal knowledge of a woman without her consent. And I'm paraphrasing there are variations of that. And the Missouri Supreme Court held that in cases of forcible rape, except theoretically perhaps, intent is not a necessary element and therefore not an issue where the facts of the particular case are such that the defendant is bound to know the nature and character of his act. Whereas here the state shows a completed act of forcible rape and it is denied by the defendant, how can it be said that there arises any real question with respect to intent? And to go back, this court's review of whether or not a law transgresses due process is whether or not it violates a principle of justice that is so deeply rooted in the history and traditions of the contents of our people so as to be ranked as fundamental. And the doctrines of actus reus, mens rea, and Sandy mistake justification, which is essentially what we're dealing with here, these are have traditionally been left to the states. And that's the Supreme Court's holding in Powell v. Texas. It's the defendant's burden to show that a law violates due process. And the defendant has not shown that any codification of rape, even those by states that have construed their rapes as being strict liability offenses, that those violate due process. And I would refer to the case of State v. Reed, which I cite in my supplemental brief. I believe it's a Maine case. The court in that case held that the legislature, by carefully defining sex offenses in the criminal code and by making no reference to the culpable state of mind in rape, clearly indicated that rape be compelled by force or threat that requires no culpable state of mind. As we reasoned previously, one person cannot accidentally or innocently compel another to submit to sexual intercourse. I think that sums up the nature of Kansas state or rape statute as well. I didn't read anything in the defendant's brief, and I haven't heard anything in his arguments before this court today showing that Kansas's rape statute does offend a deeply held tradition, principle, so deep as to be ranked as fundamental. Because he has not done that, I submit to this court that this subsection E and subsection A with it do not violate the due process clause of the Constitution. In closing, I would just ask this court to first find that to affirm the Court of Appeals finding that rape is not this rape statute is a general intent crime, that it is not a specific intent crime. Reservedly, I would ask this court to hold that even if this is construed as a specific intent crime, subsection E renders it that is within the purview of the state to define acts of criminal liability. And thirdly, I would ask this court to find that if this court does find that it is a specific intent crime, or it is a, strict liability crime, and it does run afoul of the Due Process Clause of the Constitution, that under the facts of this case, any error in instructing the jury was harmless beyond a reasonable doubt.
Are there any other questions? Thank you, Mr. Obermeyer. Mr. Mahara, you reserve 3 minutes.
Thank you, Your Honor. Just a couple quick comments to follow up on Justice Biles' question or hypothetical. My understanding the hypothetical was person A tells a woman, essentially, go have sex with person B, or I'm going to kill you. Is person B guilty of rape? And I would argue under the statute, yes, because what the state has to show is that person B knowingly had sexual intercourse with a woman. That's met. That woman was overcome by force or fear. Now that force or fear was from a third party and person B had no idea, but under the state's reading that this instruction is proper, that would make the acts of person B criminal, even though he would be operating under the belief that everything he was doing was legal. And a third person would think it was legal.
Counsel, would that my hypothetical be solved if the statute read exactly the way it does, except in subsection A, when it says when the victim is overcome by force or fear by the defendant?
It could, certainly that would be adding language to the statute, but that could be a possibility.
Okay.
I think.
So let me extend that then. If that remedies the problem, isn't that what happened in this case? Because specifically, your client litigated whether the victims was overcome by force or fear. That was an affirmative defense, which the jury apparently rejected.
The defense in this case was consent. He testified that he had consensual sex with the victim in this case. She obviously testified otherwise. The jury kind of split the verdict. They convicted my client of rape. They acquitted my client of aggravated criminal sodomy. The defense to both were the same. It was a matter of consent. I think adding that language to the statute could solve the problem, but that is adding language to the statute. I think the problem comes in with its subsection E that basically makes it a strict liability offense and eliminates any intent or any part of my client knowing his acts are criminal. The subsection A1 talks about knowingly engaging in sexual intercourse with a victim who does not consent. I think there has to be some knowledge on the part of my client that what he is doing is criminal. And when you take that away, it does become a strict liability offense. I think it becomes very much the same as statutory rape. All the state has to prove is that the defendant had sex with the victim. Beyond that, it doesn't matter. So we think it goes beyond what due process allows because it just doesn't give notice. And in your hypothetical, person B, again, would be thinking they're just having consensual sex, not knowing, not having any idea that it was criminal. And I think this idea of fair notice is deeply rooted in our criminal jurisprudence over the years. The Morris, I think it's Morissetti or Morissette case that we've cited in our brief talks about marrying the evil evil meaning mind and the evil doing hand has always been part and parcel with our criminal justice system, so that defendants are given that notice and can make the choice whether or not to commit the crime or not. So we believe that it violates due process, and we would ask this court to reverse and remand this matter for a new trial.
Other questions? Thank you, counsel. I wish to thank both counsel for your arguments this morning. The court will take this matter under advisement. We are now in recess until 11 a.m. this morning.